Welcome back to our last segment of Civil Discourse Now here on January 14th, 2012. I'm Mark Small, co-host with Paul Ogden. We're shooting from Big Hat Books, 6510 Cornell Avenue in Broad Ripple, where you can get books like Destiny of the Republic, really cool book that I'm going to be reading this afternoon. Also, they have a gallery up here with art being displayed by GC Lucas Gallery, and there's space here to rent for special occasions, receptions, what have you.
Mark, have you written a book that...
Oh, by the way, I have, yeah.
Oh,
Crime Pays, it's a fictionalized account of a Ponzi scheme in the 1960s in Indiana. And it's kind of a neat book. So, yeah.
There are rats in the book.
If you do say so yourself.
Yeah, there are rats. Rattus, and Rattus norvegicus.
Yes.
I mean, they're real rats.
Rats are fascinating.
Yes.
So, anyway,
Amazing invention, rats, when we're talking about unions.
yes, we were talking about unions, but I digress. Anyway, but one of the our audience member asked about state employment, and state employment has changed. I've been a state employee. I've worked in the Senate. I've worked for the Attorney General's office. I worked at the Court of Appeals. So I've worked in state employment off and on throughout my legal career and before. But the working conditions, or I should say the situation, whether it's union or non-union, and the protections of state employees have changed considerably. I believe they recently got rid of merit employment. I'm sure Bill, correct me if I'm wrong. And so all workers are now non-merit. There are some protections that are in.
There's a few exceptions to that.
There are? Okay. Well, maybe you can enlighten us on that. But anyway, some of the protections are non-merit employees were supposed to have protection under a Governor Daniels executive order that he issued. But having experienced those protections, they're not really there. We're not really protected. And one thing that's near and dear to my heart is whistleblowing. That state employees are in a unique position to point out misuse of taxpayer dollars, things that are going on, violations of the law. We need to protect those people. And those people are not being protected, not only by the executive branch, but by the judicial branch, in my opinion.
Bill, does that mean that state employees are at-will employees?
Many of them now are. That's right. And of course now with the governor, with Governor Daniels tearing up the executive order, the prior executive order, which authorized collective bargaining and representation by unions. They really, even if they may have some substantive protections, there's no union there to help them.
Because AFSCME is virtually gone.
The AFSCME is virtually gone.
Unity teams gone.
And not only, and this, I don't think people realize this, but last year the legislature not only said what Governor Daniels did about not recognizing public sector unions is fine, but the legislature passed a law, which they buried into the budget bill, that says no future governor can sign an executive order similar to the one that Bayh and O'Bannon entered into on behalf of state employees. We're challenging that for constitutional grounds next week, but it's just appalling to see how protections have been stripped from state workers. And I certainly agree with whoever said that they're underpaid, overworked, and they have virtually no protection. And because they don't have any protection, they are subject to political pressures.
Right. And so Governor Daniels effectively, what he did, he himself couldn't do again.
That's right. Well, no. Basically, it makes his expungement of the prior executive orders permanent. If John Gregg is elected governor and wants to recognize AFSCME, he's prohibited from doing that. He'd actually be committing a crime.
I don't know that it's permanent because, I mean, the statute can be repealed.
How do you? I've been practicing labor law for 37 years. I have never yet in Indiana seen a regressive labor measure overturned by a subsequent legislature.
Right to work actually was.
But I said that was back in the 50s and 60s when obviously union density was approaching 35%, I think, in Indiana. So there was, but it's not. Once things happen here that are anti-labor, they become permanent.
Well, I gotta defend the legislature a little bit on this. I don't know that should have been put in the budget bill, but shouldn't that decision be made by the legislature instead of by the governor with whom the unions would be negotiating. The deal is, by authorize the unions, and O'Bannon continued it, except they're supposed to be negotiating with the unions. It's supposed to be an adversarial relationship. And that's sort of, if they're saying in the first place, okay, unions, you can come on in, I don't know if that creates the necessary tension to have a fair contract negotiated there. What I was speaking about earlier, in which the other side of the table is compromise from public employee unions, I think that's in effect there, and I think it's entirely appropriate for the legislature to act on it.
But they should be open about it. I mean, it shouldn't be something that they sneak through so that nobody knows that it's happening.
I agree. I agree with that.
Because if they're going to do something that affects people so broadly, and I worked for the state. I was an employee at Purdue in the libraries for 4 years. We didn't have a union at that point. That was like the beginning of the 80s. I had no benefits. It was minimum wage. I had barely over minimum wage, but I was living in student ghetto at Purdue, and so it was like I had like very few costs. So my income was all disposable for beer and pizza and stuff.
Well, I certainly worked for the state.
Well, I mean, yeah, but I mean, to call my position an entry-level position would be to badmouth entry-level positions. It was just, and the people there who were there full-time, though, they weren't getting paid a lot more than I was, and they weren't getting any benefits.
Well, like I said, I certainly worked for the state, and I've seen from the inside the lack of worker protections and some of the lack of pay. But the question is, how do you protect state workers, local workers, municipal workers, county workers, or even federal workers, without getting into that feedback loop that I discussed? Is the choice going to be overpay like California, or crush them like they are in many places and arguably here?
I think there's a lot of political, pressures working in the opposite direction. Even if a governor agrees to recognize a union on behalf of the state employees, he understands politically that if he grants them a huge pay increase, and that's going to cause taxes to go up, he's going to pay a political price for it.
Or
So
she.
Or she.
Well, that hasn't happened in a lot of places. So that's why the budgets are busting in places like California.
In California, budgets are busting in large part because they put that idiotic property tax thing through that Howard Jarvis wanted in the 1980s, and things have just been going downhill.
They put
ever since.
they put that Property 13 deal in there because the legislature was abusing its power. It was raising taxes while sitting on a huge budget surplus.
Well, before we get off of here, there's one other aspect of this we haven't discussed, and that is this. Speaker Bosma and Representative Bauer, apparently the legislature, they've agreed to put this matter on referendum ballot, on the ballot, November ballot for referendum.
I don't think they've agreed to that. I think they've agreed to allow that as an amendment.
Okay.
Well, I mean, to hear the amendment and vote on the amendment. The amendment still has to pass.
Okay.
And the betting is that it'll fail.
Oh, that it will?
It'll
The
fail.
referendum?
Well, that's what Bauer.
That the amendment permitting the referendum will
see, I
fail.
thought it was a done deal.
Unless there's some news that's fresh as of this morning. I haven't heard that.
WIBC reported.
I think
thought that maybe
I think it's just an agreement to permit an amendment to the bill that would require a referendum.
Well, let me speak on the one thing. The Republicans know that this is an issue that's going to stir up labor. It's going to stir up the unions going into a fall election. They don't really want that.
Well, if they didn't want it, they shouldn't have brought it up in the first place.
Well, one reason to take the heat off of them would be to do it as a referendum. Say, hey, it's whatever the people want. So that I think would be a huge victory for the Democrats. Now, on the other side, you got to look at the fact that there's a presidential race and there's a governor's race and a U.S. Senate race here. It's going to drive Democrats to the polls, and that could affect the results in those.
Well, and
races.
this is happening in Ohio too, where they were pushing right to work. And Ohio is a swing state, or considered a swing state in the presidential election. And to me, it just seems, from a political standpoint, incredibly short-sighted to bring this up now, when the national election is going to be so important, and an issue like this, whether it passes in this General Assembly or whether it's put on the ballot for a referendum or not, it will increase union turnout at the polls, which historically does not favor Republicans.
Okay, oh my God, you mean, you're talking about there could be a referendum that the people are so interested in that it increases voter turnout at the polls? My God, that'd be
It
terrible.
would increase certain turnout at the polls.
Well, okay, and if the other side doesn't want it, then they should turn out for the polls too.
Well, you have to look at,
Some people are more energized
Right.
than others. on
it's not a
certain
voting
issues.
issue to both sides. It's a voting issue to the union people, to the labor people, to the friends and family. That are
I think
union.
most people don't
It's not,
care.
most people don't care. It's
Well,
not
a
voting
large
issue.
percentage of people don't care. It's not most people don't care. Number one. Number two, only one side has really been coming out and getting a lot of attention as far as facts are concerned. If voters are aware of the fact that there are studies out there that show that in non-right-to-work states, for example, the most affluent state, the highest income of any state in the United States is the state of Maryland. That's a non-right-to-work state. That's also, you know, we got the Colts from them. We got the Colts, they got the higher incomes.
You got the polls.
Yeah. So, but the whole point is, if people are made aware of the fact that there's a right to work states, and somehow change the nomenclature on this, so we're not talking about right to work, because it's not a right to work. Look, if it's right to work, it means I've got a right to that job, and it's not at will employment. And that's not what they're saying at all. It's no right to work.
I think we understand that right to work is not necessarily the most accurate way to describe it, but that's just the terminology.
It's
that's-
Orwellian. It's Orwellian. You know, it's saying something that it's not. It's just the opposite. It's not giving a worker a right to anything in that job.
Yeah.
Well, then how would we describe it in a way that people would understand
It's
the
a theft
issue?
of services. It authorizes the theft of services from unions.
Well, that's a little bit biased description of it. There.
No,
I mean,
but it is. Isn't that what it does? Because it requires unions that have a duty to represent all workers, to represent them even though they're not paying for it. And I'm paying for it, but you're not paying for it. It's sort of like saying you don't have to pay your lawyer if you don't want to, if you don't
No,
like
we don't
the
want that.
services.
No, we do not.
Yeah.
Oh, we don't want that at all. Don't want that.
But individuals can still, with the right to work bill, individuals can contract for different. They don't have to contract for exactly the same wages that the people represented by union receive, right?
Yeah, but it's not right to work. And that's one big thing, big point I think has to be made, is the irony that the same people that are pushing it as right to work are the people who are really vehemently in favor of employment at will. Employment at will means that if the employer doesn't like the fact that I'm wearing a sweater in my off hours, then that's too bad. I've lost my job.
Yeah, that's what it means. That's exactly what it means.
Unless it's part of a suspect class.
Yeah.
Race, gender, sex, religion,
Or constitutional.
And then you have to prove it.
and then you have to prove it. So that being said, I can tell you this, that my cell phone has a very loud ringer, and it's my bad on the sound that we just heard. We're at the end of the show, and I didn't introduce our guests at the beginning of this last segment. Our guests today have been Bill Groth, who's an attorney here in Indianapolis with areas of practice in appellate law, labor and employment law, election and voting rights law, and social security disability law. And Jeff Cox, who's been a guest on the show before, who practices in the area of eminent domain, wills and trusts, general litigation. My co-host here is Paul Ogden. I'm Mark Small. We've been discussing the so-called right to work law or laws that are pending before the General Assembly here in Indiana. Gentlemen, thank you for coming on the show today. It's been a pleasure and honor, and it's been fun.
Thank you.
Thank you.
Thanks very much.